This bite-sized employment law video is on the topic of notice. The notice which the employer and employee will need to provide to terminate the employment will usually be governed by the wording of the employment contract. The notice may be the same length on either side, but not necessarily. Notice on either side for a junior employee could, for example, be 4 weeks or a month. For a more senior employee, notice on either side could be 3 months, and for a board member, notice, for example, could be 6 months on either side. Notice will depend, though, on what the parties have agreed. The employment contract will usually permit the employer in certain situations, such as when the employee commits gross misconduct or gross negligence, to terminate the employment contract with immediate effect. Also, if the employer has fundamentally breached the employment contract, the employee may resign swiftly as a result of the breach. If the employment contract is silent on what notice has to be given to terminate the contract, reasonable notice has to be provided. The courts would consider what the parties' intentions were when the parties entered into the contract to determine what reasonable notice is in the particular case. Factors that might be relevant could include the employee's salary, the employee's length of service, the employee's seniority, and what is normal in the industry. After an employee has been employed by an employer for 1 month, the employee is entitled to statutory minimum notice unless the employee is guilty of misconduct, entitling the employer to terminate immediately. If the contract provides for a longer notice period than the statutory minimum notice, then the contractual notice will apply. The statutory minimum notice that employers must provide is 1 week's notice for employees who have been employed for more than 1 month but less than 2 years, 1 week's notice for each year of continuous employment for employees who have been employed for more than 2 years but less than 12 years, and 12 weeks' notice for employees who have been employed for more than 12 years. Employees are obliged to give their employer statutory minimum notice of 1 week if they've been employed for 1 month or more. There's nothing, however, to stop the parties agreeing to waive or shorten statutory or contractual notice. Contracts for fixed terms automatically terminate at the end of the fixed term, and there's no need for the parties to give notice. Sometimes, though, fixed term contracts allow the parties to give notice to end the contract earlier. It's also important to be aware that the non-renewal of a fixed term contract is a dismissal for the purposes of unfair dismissal and redundancy pay claims. For more information, visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.